I'd like to take an opportunity to introduce you to the law firm of Blackburn and Green. Blackburn and Green is a statewide personal injury and wrongful death law firm. R.T. Green and I began practicing law in 1977. We both met in law school at Indiana University and went separate paths. He became a circuit court judge and I became a deputy prosecuting attorney with a general practice. Eventually I moved on to a larger city and began practicing insurance defense and corporate defense work. RT then went to Indianapolis and began practicing with a personal injury law firm after being a circuit court judge. We got together in 1989 and began practicing as Blackburn and Green beginning in 1991. We've practiced solely personal injury and wrongful death since that time. We limit our practice and we made a commitment from day one to only practice personal injury and wrongful death. It was tough in the beginning because there weren't a lot of cases and there weren't a lot of clients, obviously, but we stuck to our plan, and today we have a statewide practice with over 14 offices. Proud to say that every founding partner at Blackburn and Green graduated from law school with honors. We made the time and commitment to graduate with honors, and that's something we are proud of. Every partner in our law firm has over 30 years of actual trial experience. That's experience in courtrooms throughout our entire career, both as judges, as insurance defense lawyers, and as personal injury trial lawyers. We've tried cases in many of the counties across the state of Indiana. One of the things that's important to us in helping our clients in their personal injury claims and wrongful death claims is to advance all pre-litigation expenses for clients. We understand that a lot of clients don't have money for a retainer for attorneys to pay expenses for getting and obtaining copies of medical records, reports, investigations, and such. The Indiana rules of professional conduct actually allow us to advance these expenses for clients. We made a commitment early on to do home and hospital visits for clients. I know some law firms like to make telephone calls and call clients that live out of the city that they're located in. And quite frankly, I can tell you that RT and I have traveled well over 1 million miles meeting clients throughout the state of Indiana. I have an old car with 540,000 miles on it. I know RT's, he's beat the road with a lot of his trucks that he drives and got a lot of miles on them. We've documented over 1 million miles making home and hospital visits. That's an important part of our personal contact and meeting clients so they can know the lawyer that's going to represent them. One of the other things that we like to talk about and offer is the fact that unlike some law firms, we offer a flat fee contingent attorney fee contract. There are typically two types of contracts in Indiana when you hire an attorney. One can be a flat fee contract, the other is an increasing fee contract, and they typically work like this. In a flat fee contract, if you hire an attorney on a standard 1/3 fee agreement, that means the attorney will receive 1/3 of the settlement or the judgment awarded at trial. The settlement or judgment is typically a gross amount, and the fee will be based on that. In addition to that, there'll be a reimbursement for the advances and the expenses that we talked about earlier. The Indiana rules of professional conduct allow attorneys to advance those expenses. It's unethical for attorneys to make loans to clients personally or to give money to clients to obtain a case. Obviously, any attorney that would do that should be properly reported. That's not something that any attorney should ever offer to a client. Attorneys should never have a personal interest in the outcome of the case other than their fee that they earn and work on behalf of the client. In the increasing fee schedule, you'll find that many firms offer a fee schedule where it may be 1/3 if the case settles. If you tell the attorney you don't want to settle the case and he files a lawsuit, then the fee may go up to 40% at that time. Others increase the fee to 40% at the time of mediation or settlement during the litigation phase. Some have even gone as high as 45% or higher if the case goes to trial. So you can see that in Indiana there are different types of contracts. At Blackburn and Green, we've always stood by our commitment to offer a flat fee contract of 1/3 of the settlement, and that is a gross fee on the settlement amount. But it does not increase if we file a lawsuit, if we file and go to mediation settlement conference during trial, or go all the way to trial and get a judgment. the fee is the same. I've often told clients one of the reasons we do this, quite frankly, is we have some very large cases that we ask clients to turn down what they consider to be a pretty good settlement, and they could certainly use the funds with what they've gone through with their injuries, their suffering, their medical bills, and their lost wages. If clients know that we don't get any increase in fee if we tell them to turn down that offer, unless we get more settlement or more verdict. In other words, a greater dollar amount of settlement or verdict by filing suit. We hope that builds confidence in you, that we know what we're talking about, and we can make our best efforts to achieve that. Otherwise, our reputation is on the line for you and everyone you know, and your family, your friends, your coworkers, everybody in the town you live in. So that's very important to us. Our goal is to be a leader in the personal injury and wrongful death practice in the state of Indiana. We know that attorneys from out of state, as far as Chicago, Phoenix, Ohio, New York, wherever, have advertised in Indiana. And we expect more competition in this field in the future, and that's okay. But we want to be a hometown Indiana personal injury law firm, and that's what we want to be recognized at. And we're going to, just like we made the commitment to stick with you and stand firm in our practice of only personal injury and wrongful death, we're going to stand firm and be hometown Hoosier lawyers. That's our goal. That's what we're committed to, and we're standing firm.